Oh, it's dark, so it must be legal AF after dark. The immunity decision by the United States Supreme Court will go down in history as an abomination, as a scourge, as one of the worst decisions the Supreme Court has ever made. Now we have to pick up the pieces and figure out exactly how it impacts something like the New York convictions of Donald Trump, which have been delayed for sentencing until September. We discuss it, we debate it, we break it all down for you, one place, and the only way we know how, on Legal AF, the podcast. Take a listen.
So back to the decision and why it's so bad and how it applies to the New York case. So just to remind everyone the basics of the decision, which is essentially there are two categories. There's official and unofficial acts. And if it's unofficial, then you can be prosecuted for it. If it's official, or there's kind of two branches under the official. There's the absolutely no matter what official, and then there's the, okay, we're going to presume it to be official, but you can rebut it. But you can't rebut it with evidence of things that might be official. You have to look some other way. And so, but essentially, if you get into the official acts or official conduct category, it is, you cannot prosecute it, nor can you use it as evidence in your case. The evidence is out. The evidence can't even be looked at to look behind. What were your motives? What were you thinking? What were you intending to do? And that's where I think the real harm comes in. Now, the New York case, you look at it and you say, okay, but that already happened. And that wasn't the law at the time, right? If you, Judge Chutkan addressed the issue of official immunity and said, there is no official immunity, or I should say absolute immunity. There is no absolute immunity for presidential immunity for committing crimes, right? That's what she said. She didn't even say, well, if it's within your job description or in the outer perimeter, that's civil talk, right? That's what they talk about in the civil world. You can't be sued for things that are your official acts, things that are in your job description. And that's the case for all sorts of people, right? Police officers, judges, members of Congress, and the presidency. That was always the law. That's what we understood. Numerous cases talked about that if you're within the outer perimeter of your job description, you can't be sued civilly. But nobody ever thought it applied to criminal, including Nixon in the Nixon era and the Nixon cases. Everybody now thinks, wow, Nixon would have been found to be immune, and he had to be pardoned. That's how much everybody assumed that was criminal at the time. So essentially, Judge Chutkan ruled that we're not even going to go there and look at whether this is official or unofficial, because committing crimes can never be in your job description. Now, I'm oversimplifying it all, but that's essentially what she said. Went up to the DC Circuit. They held the same thing. They didn't even they didn't even kind of have any sort of, well, these things are official, these things are unofficial. They didn't parse it out like that, because again, it would be preposterous to think that you can do whatever you want, like order SEAL Team 6 to assassinate your rivals, like accept bribes in exchange for a pardon, etc. All the things that they talked about during oral argument. Well, then it went to the United States Supreme Court and they ruled, not so fast, hold on. Presidents are kings. Presidents can get away with this. And they made this whole distinction here. And now they're sending the case back down to Judge Chutkan to figure this out. But how does that impact New York? They've already had a fact finding. They've already had a trial. All the witnesses have testified. The evidence is in. Well, on the one hand, you would say this was all personal. That was all litigated, right? That was all completely litigated. Trump's lawyers talked about that this was personal. That all happened when he tried to get removed to federal court under Judge Hellerstein and said, no, this is personal. This was my personal attorney. And there was no question about that this was personal. That was even his whole argument at the trial, right? His whole argument at trial was this had nothing to do with the election. This had nothing to do with anything with the election. This was just personal. I just didn't want my wife to know, right? This wasn't election interference. I just didn't want my wife to know about it. That's why I paid this off. That was their whole defense. Their whole defense was this was personal. So you would think, oh, so this should just fall into the unofficial acts category, right? This shouldn't even be impacted at all by the case. P.S. All the other cases might not ever get prosecuted because he might be immune. And so a lot of people were criticizing this case when it was brought. Why this case? This case, I don't understand. This isn't so serious. Why is this going first? Why is this going at all? Well, guess what? Now that we have this decision, this might be the only case, the only conviction that stands, because all the other cases will be impacted by this decision significantly. So again, his entire defense in the New York case was very much, this is personal, unofficial. But this is where it gets tricky. It gets complicated because one of the worst part of this decision, although right now my feeling it's the worst part of the decision, I'm sure I'm sure that'll change depending on what it's impacting. But right now, the worst part of the decision, in my opinion, is that it talks about you can't even use evidence at a trial, a criminal prosecution against a former president. You can't even use evidence, even if it's personal like this, of anything that was official, of anything that could be considered an official act. That can't come in. And when you look at the evidence that was introduced at trial by the Manhattan DA's office, my old office where I worked for 30 years, when you look at the evidence, there's certain piece of evidence that under this Supreme Court ruling might be held to be impermissibly admitted, might be held to be official, essentially. And I'll tell you where I think the area that I'm most concerned about, and that was Hope Hicks's testimony and Madeleine Westerhout's testimony. Those are two White House employees that testified at the trial. Hope Hicks, interestingly, talked a lot about the importance of how much they didn't want that Access Hollywood tape to come in, if you remember, because the campaign was really, really, really upset at the time, and we're thinking it was devastating. They were trying to keep it out. And her testimony was very important. And what worries me about this is normally a judge could just look at that and say, you know what, I hear you. I see that probably falls in this category, might have to come in. You might rule that no, she was helping candidate Trump, and there was a blurring of the lines there between the campaign and the president. But she was a White House employee during some of the conversations, especially when Donald Trump said to her later on, if you recall, one of the part of the testimony that I think was really damaging. I was actually in the courtroom for this. It was the one part of the trial that I saw when she was talking about while he was president, months later, I think it was April of 2017, he said to her something to the effect that he was glad that this didn't come out at the time before the election, and he was really focusing on the election. It was such devastating evidence because he said, "Gee, I'm glad this came out now and not before the election," because obviously that was really an important factor for the prosecution, right? This had to be an element of the crime that they had to prove beyond a reasonable doubt that this was election interference. And this was a piece of evidence that they really relied heavily on. And in the courtroom, that's when she broke down crying, as if to having felt the weight, realizing, oh my God, I just sank Donald Trump. Because that was, to me, it was one of the most devastating pieces of evidence in the whole trial. It felt like a Perry Mason moment. Now, what concerns me is, in summation, Josh Steinglass actually he actually talked about how important this was. His closing argument, he said, I have the quote right now. It said, okay, he said, answer, oh, yes, he wanted to know how it was playing and just my thoughts and opinion about the story versus having the story a different kind of story before the campaign had Michael not made that payment. And I think Mr. Trump's opinion was it was better to be dealing with it now and that it would have been bad to have the story come out before the election. Josh Steinglass then went on to say, that is devastating. That's from the defendant's own communications director, who still respects and admires the defendant so much. That was the last thing she said on direct, and she basically burst into tears a few minutes later, a few seconds after that, because she realized how much this testimony puts the nail in Mr. Trump's coffin.
But by the way, one comment. Westerhouse bursts into tears all the time. She burst into tears when she lost her job for making an impertinent comment.
That was Hope Hicks.
About no, it's Madeline Westerhout. Madeline Westerhout, I'm looking at the article right here. She got fired because she made an impertinent comment about Ivanka and Tiffany, and she got canned, and she was in tears. She's in tears a lot, but that's not your point. I just want to make a point.
Yeah,
we all responded to her being in tears. She's always in tears. She's a young woman that constantly seems in front of the press to break into tears.
Yeah, well, Hope Hicks also broke into tears.
Yeah.
I was in the courtroom, so that was what I was just referring to, was Hope Hicks's testimony. And so essentially, what ended up happening there was Josh Steinglass said in summation. His whole summation was all about how you don't have to rely on Michael Cohen. There's so much corroboration, and one of the things he relied on right there was that testimony, that Hope Hicks testimony. So it was pretty devastating. Like I said, I was in court when it happened, so I experienced it in real time and saw how devastating it was. And that's what concerns me, is the judge is going to have to make a harmless error analysis. Now, there is mountains and mountains of evidence that prove Trump is guilty. I do think that the judge will ultimately find that it's harmless error. But given that the summation is all about, you don't have to just trust Michael Cohen, it's all this corroboration, the fact that there is evidence that might fall into this official category is something that the judge is going to have to grapple with.
What's the official conduct bucket that falls into? The conversations with Hope Hicks, Westerhout, Rona Graff over the Trump, which is the link of the three. What's the official conduct bucket? Why isn't that private?
Because she was working in the White House, just like the same way that any discussion with Jeffrey Clark. So the United States Supreme Court said, for example, any conversation with Jeffrey Clark, immune. Doesn't matter what it's about. It's immune. Your part of your job is to speak freely with your direct employees. At the time that Hope Hicks and Donald Trump had that conversation, that was in April of 2017. That was while she was a White House employee. It was after the Access Hollywood tape did come out and the Karen McDougal stuff came out. Yeah. All of that was coming out.
But I don't think that's I don't think the Manhattan Year-Old Office lays down for that. I think they argue that either it's unofficial conduct or it's official conduct for which they can overcome the presumption by arguing that it is not going to be an improper impairment of the executive branch, because all he was doing, Westerhout, all she was doing was schedule Michael Cohen to come to cover up a private affair and negotiate over the checks and the legal fees. And all that what's her name was doing similarly fell into to cover up without motives. I get that, but you don't think your office is just going to go, go right to harmless error? Aren't they going to try to argue it's in one of these two buckets?
Yeah, they're gonna argue all of that.
You want to come in?
Yeah, I was just going to say, I mean, I think the content of the conversation is going to have to matter, and not just whether or not it's employee. Otherwise, the whole Monica Lewinsky thing would be considered, official conduct. So I think there's going to be, yes, that person was an employee, but were they talking about something within anything official? And I don't think that conversation he could argue even was official, because it was clearly about the campaign before he was elected. So to me, I think the content of the conversation, yes, like they're going to have to go through that once that person is an employee. They're going to then have to go through whether or not the conversation itself had any connection to his official conduct. But to me, it seems pretty clear that that was a campaign conversation.
Yeah, but the campaign's over. Right. So at that point, he had already won, and she was a White House employee. Look, I think the Supreme Court. We'll see what Judge Merchan says. I think it's going to be pretty clear that is going to fall into one of those categories. Whether it's going to be interesting to see whether he finds it to be harmless error or not. But there's another thing I want to bring up that I think is where I'm landing in terms of this case. At first, I dismissed this argument in my head, but now I'm landing as this is probably the most important thing that Judge Merchan is going to have to rule on, which is that, look, Donald Trump waived all this. This issue is waived. He waived it with Judge Hellerstein during removal. He then blew the deadline again when he was back before Judge Merchan during the time when he said motions, this is the deadline for motions in limine. And then after that deadline, but before the trial, he filed a very detailed statement of Donald Trump, of what he would have argued. So the exact scope of the waiver is quite detailed, and he can't claim that he didn't think of these arguments before the court ruled, because he filed this detailed kind of presidential immunity in 2 times that was not timely. And in front of Judge Hellerstein, he clearly waived it. He blew the deadline before the motions in limine. And so I'm going to argue that they better make a waiver finding.
Oh, yeah. But here's the counter to that, to play devil's advocate. When Alina Habba argued to the Second Circuit about E. Jean Carroll and the failure to raise immunity then, the judges on the Second Circuit did say at the time, didn't you waive this? And Alina Habba said in response, it's not waivable. In other words, it either is immune or it's not immune, or whether we raise it or not, it's not that kind of defense that if you don't raise it, you've waived it. What strengthens Donald Trump's hand on, I may have not raised immunity prior to this, but the immunity as now shaped by the July 1 decision by the United States Supreme Court was not on the books. You can't waive that which did not exist. He's going to argue this is not a waivable issue. I'm either immune under the various categories of immunity now established by Trump versus the United States, or I am not. And whether I raised it or not, it's not incumbent. It's not what drives the defense. Now, I don't know what the result of that's going to be, but that is going to be Donald Trump's argument. It's new law. It wasn't on the books back when I was arguing this. It is on the books now, and I need to be able to take advantage of it. That's going to be the debate, won't it?
Of course. Yeah, you're 100% right, Popok. But I still think there's a strong waiver argument that the judge, hopefully, look, a lot of this is academic. Obviously, there's now significant appellate issues, so there's no way Donald Trump is going to go in. If he ever was going to go in, it's going to be stayed pending appeal if the judge sentences him to incarceration while they litigate this. And of course, we'll already know if he's president or not once these appeals happen, because these arguments have been postponed until September, so the sentencing is put over until mid-September. And as you know, to appeal these types of issues, it can take years, maybe even months, maybe years. And so one way or another, we'll know if he's president. If he wins, he's never going to serve the sentence, and it'll go up the appellate chain one way or another. And if he loses, then all of these issues will be fleshed out. It'll have to go to the appellate court in New York, up to the highest court, and then it'll make its way up to the United States Supreme Court.
Let me turn it over to Dina about New York, and then we can segue into your leadership today on your thought leadership today on Mar-a-Lago and what's happened just today in yet another paperless order by Judge Cannon. She should write a memoir that's just called Paperless Orders by Aileen Cannon. So why don't you give us your thoughts on New York, and then we'll go right into Mar-a-Lago.
I think I kind of said it a little bit. I think the content of the conversation is going to be really important. They can look at surrounding evidence. I think that it was clear that the content was not part of him carrying out his duties of the presidency. The fact that the check was signed by him personally, and that he kept saying that this was Michael Cohen was his personal attorney. I see Karen's point about this is exactly what the Trump attorney is going to raise. But I think that the content is pretty clear that it wasn't about what he was doing in office. And so I think at the end of the day, it will stand. But to the point that the Supreme Court opinion is pretty awful. We've talked about this so many times. They don't have a very clear standard that they set out to give to the judges. And a lot of it will depend on that particular judge's opinion. let's say, and it is going to have to work through the court system because this is all novel and this is all new. But I do think ultimately that conversation was a private conversation and not an official one.
So listen, it's going to get played out. There's going to be full briefing. The judge hasn't set that, I don't think yet, but we'll see all the briefs. We'll be able to comment on all the briefs. We'll know all the positions, and we'll give our best guesstimate and opinion about how this will shake out with Judge Merchan, who so far has not made a false step, just as the Manhattan DA's office hasn't made a false step in this case. They'll get it right, and we can trust that they will. Welcome back. That was Legal AF, a little podcast that we named 4 years ago for a good reason, Legal AF. And if you don't know why, join us on Wednesdays and Saturdays at 8 p.m. Eastern Time, and then on audio podcast platforms of your choice. We curate the top 4 or 5 stories at the intersection of law and politics. We bring it to you just that way, the only way we know how, uncensored, unfiltered, and with experience of being in the courthouses and courtrooms that we talk about. We're lawyers who know what we're talking about at the intersection of law and politics, and we invite you to join our audience. If you're already part of our audience, thank you for being there. Take that clip, if you will, send it off to people in your life and ask them to join our audience as we continue to grow towards 3 million free subscribers. And if you don't know anything about Legal AF or our content or what we do twice a week, every week for the last 4 years on the MeidasTouch Network, I invite you to join our audience. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.